In this case, a man named Bayliss was promoting a new insurance company. One of the things he needed to do was find capital for the new company, so he approached Eley, a solicitor. Eley agreed to advance £200 to the company in instalments, and in return, he would be appointed as the permanent company solicitor. Just before the final payment, the company was duly incorporated by 7 shareholders. Eley was not a shareholder. The articles of incorporation included a statement that Mr. William Eley shall be the solicitor to the company and shall transact all the legal business of the company for the usual and accustomed fees and charges, and shall not be removed from his office unless for misconduct. Shortly afterwards, the £200 debt was discharged by issuing Mr. Eley 200 shares in the company worth £1 each. He agreed to this arrangement. No board resolution was passed to formalise Mr. Eley's appointment, and it seems that none of the other board members knew anything about the promise that Bayliss had made that he could be permanent solicitor in return for the £200, which in any event had now been paid off. A year or so later, the company, for whatever reason, started using other solicitors. Eley was most upset, and he ultimately sued the company for breach of contract for giving its legal business elsewhere. The company's defence was that there was no contract, and the Court of Exchequer agreed. Baron Amphlett said, "The articles, taken by themselves, are simply a contract between the shareholders inter se, and cannot, in my opinion, give a right of action to a person like the plaintiff, not a party to the articles, although named therein. The arrangement between the plaintiff and Mr. Bayliss is not noticed in the articles, and is not found in the case to have been at any time communicated or known to a single shareholder or director, or except themselves to any officer of the company." In some ways, this is an odd decision because a promoter can bind a company to contracts. The real problem is that Bayliss did not inform the company of the contract he had entered into. Still, from this case, we learn that a company's articles of association form a contract between the company's members, but not with third parties.